advance. And once the recording starts, we'll do a quick welcome, and there we go. I think we've started now. So, okay, welcome everybody once again. And I hope you're ready for what promises to be another excellent session from the CPA. I'm looking forward to it, and I'm delighted to introduce Chris Katkowski KC, who is the UK's leading planning barrister.
Keep going. Sounds good so far.
Well, I recently met Chris when we were sitting sometimes at opposite sides of the table, and sometimes on the same side of the table at the Greater Manchester Spatial Plan examination in public. And I have to say, I learned an awful lot from that experience. So I asked Chris if he would take the time to come along to one of our sessions to share his expertise with us. And Chris specialises in planning, of course, and he has many planning inquiries, judicial reviews and other planning related activities under his belt. And today is going to help us to understand some of the key aspects of the examination in public. Just before I hand over to Chris, a reminder to put questions in the Q&A tab if you can see it. If you can't, we will accept questions in the chat as well, because we know it doesn't always work for everybody. So with no further ado, over to you, Chris.
Thanks very much indeed. I hope you can hear me all right. Excellent. My screen is now lots of people's first names and initials. So welcome everybody. And as was just being explained by Marge, I'm going to just sort of go through a few key points about examinations in public into local plans. And when I've done my party piece, or when I get some message telling me to shut up, I shall stop. And then obviously I'll be very, very happy to answer all your questions, preferably questions which have something to do with what I've been talking about, but I'm open to all offers. I'm also multitasking and missing people at the same time here. So, okay, so as has been explained, my name's Chris Katkowski. I'm a King's Counsel. I specialise in planning and have done for a long time. And amongst the things that I do, I appear on, whichever side of the room my client's sitting on, at examinations in public into local plans. So what on earth is an examination in public? Perhaps we should rewind and ask ourselves what on earth a local plan is. A local plan is something which is meant to be made by a local planning authority or local district borough council, and the plan is meant to set out what the local authority wishes to happen and not to happen over a period of at least 15 years. And if you think about local plans, they really do three main things. First of all, they, most controversially perhaps, they allocate land, or they're meant to allocate land, and they allocate land for things such as housing development, business development, retail, whatever it might be. Secondly, they designate land, and designate in this instance means designate, for example, land as green belt or as protected landscape or as protected ecology or any of the other protections that are in the planning system which local authorities are capable of designating. There are some designations which are set at a national level and so aren't for individual local authorities, but most designations are for individual local authorities to make. And then thirdly, they set out planning policies which relate to how proposed development is to be, modern speak is managed. The old-fashioned speak was controlled. So how development is to be managed or controlled. And so policy was set out all sorts of very often aspirational statements about what it is that development is meant to achieve. So in today's age, there's an awful lot of policy about the look of development. Doubtless everyone would have heard of the government's drive at national level for development to be beautiful. So you get lots of design policies, for example. You get lots of policies about sustainability, about climate change, and then descending right down to all sorts of, nuts and bolts and the nitty-gritty of development. So if you think about local plans allocating, designating and setting out policies for a period of at least 15 years. And the overall purpose of a local plan is probably captured very well in a particular paragraph in national planning policy being set by central government, primarily in a document called the National Planning Policy Framework, or the NPPF to use its acronym. And in paragraph 11 of that framework, which is going to pop up on the screen here, and perhaps if we just budget up a little bit, so we've got that's it. So at the top of the screen there, you should just see setting out. If you just drop it down, that's it. That's perfect. Thanks, Marge. Marge is doing a superb job here, sharing the screen, showing some. There will be 3 passages from the framework, so there won't be too much of this stuff for us to look at. But here's paragraph 11 from the framework. And this paragraph sets out something which is called the presumption in favour of sustainable development. Your views will vary as to whether what it actually contains is anything to do, if you like, with sustainable development per se, where we're going to tackle this subject slightly later on in this little chat. But this is the plan-making part of the presumption in favour of sustainable development in the National Planning Policy Framework. So if you want to find a almost literally at a glance explanation of what on earth central government thinks local plans should set about to do, you'll find it here in the plan making part, which is on the screen. So we're told for plan making, A, plan should promote a sustainable pattern of development, and it's meant to align development needs, growth, infrastructure, improve the environment, mitigate climate change, etc., and adapt to its effects. And then particularly the next part, B, is something which is going to come up at a lot of local plan examinations. That's to say that strategic policies in plan should, as a minimum, provide for objectively assessed needs for housing and other uses. I'll say a few words more about that a bit later on, as well as any needs that can't be met within neighbouring areas. As a footnote number 6, you don't worry about scrolling down to find it. That simply refers to statements of common ground, and we'll talk a bit more about those later on. Unless, so we start with at item B, you're to, as a minimum in your local plan, provide for objectively assessed needs, for example, for housing, unless, and here come the 2 caveats, which are, depending on which side of the debate one's on, all important. And the first caveat is that the application of policies in this framework that protect areas or assets, I'm sorry the language is so clunky, but this is not a bit I wrote, that protect areas or assets of particular importance provides a strong reason for restricting the overall scale, type or distribution of development in the plan area. So just pausing there, what on earth does that mean? Well, in the footnote, which is at the bottom of the page, again, no need to scroll it up for present purposes, footnote number 7 refers to things such as the green belt, areas of outstanding natural beauty, national parks, heritage considerations, and so on, things like that. And so if you find that you have, for example, a lot of housing that ideally you should cater for in your local plan over the next 15 years, but you find that, for example, protecting the green belt or protecting areas of outstanding natural beauty or protecting heritage or such like provides a quote unquote strong reason for restricting the amount of development that you're to provide for, then in this passage of the framework, one is allowed in making a local plan to say, well, enough is enough. We've got development needs of X, but we can only cater for 2/3 of X because of these constraints, if you like. And the second caveat on the fundamental requirement to meet one's development needs, the second caveat is in B little 2, That's to say, where any adverse impacts of doing so, any adverse impacts, any harms that will arise from meeting the need or from making provision for meeting the need would significantly and demonstrably outweigh the benefits. That's to say, the benefits of meeting the need when assessed against the policies and the framework taken as a whole. So this is, as so much of the framework, this is very, very judgment call heavy, if you like. It very much involves making judgment calls. And here, one would, as a plan making council, be able to say or be able to argue at an examination, well, we know our development needs are, very large, whatever they might be, but the harm involved in meeting all of those needs would be so great that that would significantly and demonstrably outweigh the benefits of doing so. I have to say, in my experience, in doing local plan examinations on both sides of the line, that's to say, both promoting local plans and objecting to local plans, of these two caveats, it is the first of those two caveats that more often comes up, if you like, in reality, in discussions and examinations. That's to say that there's some protective designation which really should stand in the way, if you like, of meeting all one's development needs. So that's a brief outline of what a local plan is meant to do. So a local planning authority, after consulting, going through several rounds of consultation usually, although the minimum requirement in the statutory provisions and the underlying subordinate legislation is for 2 rounds of consultation, or 2 rounds of letting the public know what it is the local authority intend to do in their local plan, and asking for representations about that. So having consulted and the council having decided that it thinks its plan is at a stage when it's ready to be subjected to being scrutinised, if you like, then at that stage, under the various statutory provisions, the local planning authority has to be the full council. The full council will resolve to submit the plan to the Secretary of State, to submit it to central government for the plan to be examined. So here we see that interplay between local and central government. So local planning authority writes its plan in draft, it sends it off to the Secretary of State, and the Secretary of State then appoints usually a single inspector, but some plans are, some draft plans are so complex, if you like, that sometimes you come across more than one inspector. Marge was referring in her very lovely introductory piece earlier on to having met me recently at the Greater Manchester Places for Everyone examination, which is basically a series of 9 local plans planning for the future of 9 of the 10 Greater Manchester authorities. One authority Stockport dropped out at a late stage, and because it's, that is a complex and big beast, 9 local plans catering for virtually all of Greater Manchester is quite something. So in that case, the Secretary of State has appointed 3 inspectors to examine the plan. And the way in which it works is that if you have made a representation on the draft plan at the stage when it was submitted to, when it was publicised before being submitted to the Secretary of State, if you've made a representation, then you're entitled to be heard by the examining inspector or inspectors. And the examination in public, which is what this chat that we're having is meant to be about, the examination in public is the process by which the inspector or inspectors set about examining the plan. That's to say, the inspectors will read a vast amount of written material. They will read the representations made about the plan, both objecting to it and supporting it, objecting to bits of it and supporting parts of it. And they will hold a public hearing session or sessions, usually over a number of weeks, sometimes in the more complicated cases over months. And during these sessions, and we'll come to how they work shortly, during these sessions, the inspectors will give people who have got the entitlement to be there will give them a chance to say what they wish to say and to discuss what they wish to discuss about the contents of the plan. The task of the inspector who's been appointed to examine the plan, the task of the inspector is to do, fundamentally, to do two main things. First of all, to see whether it meets all legal requirements. So as you may or may not know, for example, plans have to be subjected to something called a sustainability appraisal or strategic environmental assessment to see how the contents of the plan marry up with various environmental objectives. And that's a process which is required by law. And one of the inspector's tasks in examining a plan is to see whether or not that process has been carried out in accordance with the legal requirements. Another legal requirement that you may or may not have heard about is the duty to cooperate. This is a duty on the part of plan-making authorities to discuss with neighbouring authorities the draft plan that they wish to bring forward, that the authority wishes, the primary authority, the plan-making authority wishes to bring forward. And very often the purpose of these duty to cooperate discussions is to see whether neighbouring authorities wish the plan-making authority to take some of their housing need and deal with it in the plan that's being drafted. So take some of the pressure off, if you like, neighbouring authorities. So that's another legal requirement, is to cooperate with one's neighbours. I'm truncating a lot of the detail of this. So that's the first main task an examining inspector has, to check whether the legal requirements have been met. And the second main task is a very, very judgment call heavy task, which is to see whether or not the plan is sound. Sound is well, the concept of soundness is it's a very unusual concept in legal circles, if you like. It's, I suppose, a very unusual word to find in legislation. But a plan has to be sound in order to be adopted. One might ask oneself, what on earth does that mean? To which I probably would say, well, that's a jolly good question. The law doesn't tell you what a sound plan is or what a plan needs to do in order to be sound. That's all left to national policy. And Marge is just going to share the screen with paragraph 35 and of the National Planning Policy Framework. And you'll see on the bit that's on the screen now at the end of the passage before the colon, plans are sound if they are, and then we'll find four tests of soundness. And they are, I'm just at the moment going to recite their headings because shortly I'm going to be running through each of them in more detail. But at the moment, just to recite their headings, plans need to be positively prepared, they need to be justified, they need to be effective, and they need to be consistent with national policy. You might notice particularly that last point, by the way in which all these things seem to go around in circles, that you have a local authority making a local plan, setting out its policies locally, but they have to, in order to be sound, they have to be consistent with national policies, which are set out by central government nationally. So there's a sort of certain circularity in these policies in the planning world. So those are the four tests of soundness, and the inspector examining a plan in public will in effect hold the plan up against these four tests and see how well or otherwise the plan fares in relation to those tests. And what on earth does the inspector do, having considered all of this stuff, having asked him or herself, well, does this plan meet the legal tests? Does it meet the four tests of soundness? Well, the inspector has the task of reporting back to the local authority. The inspector has the task of reporting back to the local authority to basically advise the local authority as to whether their plans meet the legal tests and or meet the tests of soundness. And the inspector has the power to recommend what are called main modifications, MMs, as they're in the jargon of these things. And a main modification is where the inspector has a plan which he or she is examining, and the plan is in some way deficient. It doesn't meet one or other or a number of these tests of soundness, but it could be made sound in the inspector's view if it's changed in some way. So, for example, perhaps most controversially, if a local planning authority making a plan has, for example, catered for, pick any number you like, 10,000 houses, new homes over the 15 years of the plan's life, but the inspector is convinced that in order to be sound, in order to be those four things that are set out on the screen, the plan should actually provide for a good deal more housing than that, then the inspector can say to the local authority, well, the plan isn't sound as it is, but in order to be sound, it needs to make provision for more housing, and my advice is that in order to be sound, it needs to make provision for, rather than 10,000, 12,000, or doesn't matter what the numbers are. I'm just making them up for the sake of illustrating the point. Plainly, if the inspector thinks the plan is sound as it is and doesn't need any adjustment, then the inspector will say that. But in my experience of doing these things, and nationally, I'm not aware of there having ever been a plan that's got through the examination process and emerged unscathed. I mean, it is simply a fact of planning life, if you like, that there's always something that needs to be done to a plan in order to make it sound. I'm yet to come across a plan that, if you like, was perfect when it was submitted. And of all the various tests that I've mentioned briefly, albeit briefly at this stage, that's say the legal tests and the tests of soundness, if the local authority in making its plan has tripped itself up, has got something wrong, hasn't written a plan in some or other way that the inspector thinks is sound, hasn't met one or other of the legal requirements, in every case apart from one, the plan is capable of being salvaged. The inspector can, for example, as I've said, recommend a main modification to make the plan sound. If the inspector thinks one of the legal requirements hasn't been met, the inspector can draw attention to that, and there are ways in which that difficulty can be fixed. For example, in relation to the sustainability appraisal of the plan, holding it up against various sustainability objectives to see whether it meets them or not. If the inspector thinks the reporting work hasn't been done adequately, then the inspector can simply indicate that the work needs to be done again or needs to be supplemented. Some particular point needs to be looked at in more detail or whatever it might be, and the point can be cured, if you like. The problem can be resolved. There's one exception to that. There is only one pass or fail test in all of this as things stand at the moment legally, and that is the duty to cooperate. Because the duty to cooperate, this duty to discuss matters with one's neighbours when making a plan, is a pass-fail test at the time when the plan is submitted to the Secretary of State. So if the duty to cooperate hasn't been met as at submission, and the inspector thinks it hasn't been met, then the inspector really has no option other than to say, well, you haven't met the duty to cooperate, and that means the plan basically just grinds to a halt and can't be taken any further forward because of that failure to meet the duty to cooperate. But that's the only pass-fail test in planning. Everything else is capable of being resolved in some or other way. And ultimately, the local planning authority can decide whether to adopt the plan, but the local authority can only adopt a plan in accordance with the inspector's recommendations. So if the inspector has said, this plan isn't sound as it is now, but it would be sound if you changed it in the following ways, the local authority, if it wishes to adopt the plan, can only adopt the plan in accordance with what the inspector said. If it doesn't like what the inspector said, for example, if it thinks the inspector has told it to accommodate far too much housing as far as it's concerned, or to remove some designation that it's made and the local authority doesn't like that, then the authority's only option in those circumstances is to withdraw the plan, just remove it from the system. So although legally speaking, the inspector's report isn't binding in the sense that the authority can withdraw the plan if it doesn't like what the inspector's told it should be done. In reality, if the authority wants a plan, wants to put a plan in place, and it can only adopt the plan in accordance with the inspector's recommendations. So You know, these are, if you like, recommendations with a capital R. They are very effective, if you like. And then moving on from that, there are other kinds of modifications that can be made to a plan. If the authority wants to tidy up the plan, well, I say sometimes, pretty much always, there are little glitches with submitted plans. As long as those changes don't relate to soundness, as long as they aren't things that are necessary in order to make the plan sound, then the local authority can make those changes, those minor modifications, or not main modifications, can make those smaller modifications itself. They're not the business, if you like, of the inspector, although very often inspectors will be interested to know what minor modifications the council might wish to make, but they're not actually a matter for the inspector to report on and make recommendations about. So tidying up the plan is left to the authority. So what's an examination in public like? Well, Marge will probably be able to tell you as much about this as I can from her recent experience, extensive experience. She attended, you know, nearly all of the days at the several months of the examination in public into the Places for Everyone plan in Manchester, Greater Manchester. But basically, an examination in public, in terms of the public's involvement and engagement with it, is really a sort of round table discussion led by the presiding inspector, led by the inspector who's been appointed. And the inspector will have an agenda, as in not a hidden agenda, but an agenda as in things written on a piece of paper that will be distributed before the sessions. And that will set out the topics and the subtopics and the points that the inspector wishes to have discussed openly in public at the examination hearing on that particular day. And there will be agendas, obviously, for every day of the examination hearings. And the inspector will lead the discussion. Usually what will happen is the inspector will say, right, well, the first point on my agenda is whatever it might be, and I'm just going to invite the local planning authority, the plan making authority, to say a few words just to set the scene and to set out in summary the plan making authority's position on the point, whatever it might be. Plan making authority then speaks for a few minutes through whoever it is it's appointed to do that job. And then the inspector will open up the discussion to the body of the room, and the inspector would do this in a structured way. So, you know, there are nameplates you put on end if you wish to say something. The inspector would go through each in turn, everyone who's put their nameplate up and wishes to say something on the point, whatever it might be. We'll go around the room. Sometimes we'll go around the room several times, and then sooner or later, having gone round the room and heard everyone's points, everyone who wishes to speak has made their points, the inspector habitually would go back to the local planning authority and say, well, you know, are there any points that you'd like to respond to? And the council will then respond. Normally that, and in the way in which things are meant to work, that's meant to be the discussion on that point. So local authority starts, everyone who wishes to say something about it, you know, machine gun the authority, everyone who wishes to say something about it gets a chance to say whatever they want to say about it, you know, get their points off their chests and so on. And then it comes back to the authority to, in effect, reply, and then the inspector should move on to the next point. But very often what happens is, you know, local authority gives its reply, and that provokes the number of people to say, oh, I want to say something more now. And, you know, you might go around the table 2 or 3 times before the inspector moves on. It all depends on, to be honest, it all depends on which inspector's been appointed and how strict or lenient they are. But it's a relatively, I mean, Marta would be able to speak more about this, to be honest, but it's meant to be a relatively informal process. It's not meant to be overly stuffy, if you like. It's not meant to be like being in a court, for example. It's meant to be a forum in which people can say what they wish to say, within the bounds, obviously, of you know, showing respect for fellow speakers in the room. But you won't get long. I mean, even the authority promoting the plan won't get long to speak. I mean, it's a few minutes on each person's part, and then the inspector will move on to the next person, the next person, the next person. And so because the process only gives only allows, if you like, each person a few minutes to say what they wish to say. I mean, these aren't speeches that take, half an hour or an hour. They are, 3, 4, 5 minutes. Because the process doesn't give long for each person to say what they wish to say, then it just makes common sense, but in any event, it makes good sense as well, to focus whatever one wishes to say on points which directly relate to those tests which I've mentioned to you. So if it's a session which is usually held at the beginning of the hearing process about legal matters, then if you've got something to say, if you don't think local authorities met its consultation requirements, if you don't think the authorities' sustainability appraisal is up to scratch, then focus, try and get a razor sharp focus on laser sharp focus. Metaphors mixed up here. Try to focus very specifically on what it is that you say is wrong in relation to that particular point. When it comes to soundness, these more judgment heavy issues, then if you think there's something wrong with the plan and you want to explain what's wrong with the plan, try to relate that to those one or other of those 4 tests that are up on the screen now, because what one has to remember is that the inspector's only really going to be able to do anything if the inspector thinks the plan isn't sound, if the inspector thinks the legal tests haven't been met. So one has to focus, try one's best to focus on, if one's making a point, well, why does that mean the plan isn't positively prepared, for example? Why does that mean it's not justified or effective or consistent with national policy, whatever the particular point is one wishes to make? So it's certainly, in my experience, it's more often than not the case that people will speak around a subject and won't actually sort of directly bring their points to bear on the tests of soundness. And that to me is a great shame, if you like, because it reduces the potential effectiveness of the person's contribution to the process. Not, if I'm the local authority promoting a plan and someone doesn't make a very good job of opposing it, then someone like me would think, well, that's good, isn't it? But I mean, trying to be sort of straightforward about this, as the process is meant to be one in which everyone's trying to help the inspector to come to a view about whether the plan is sound, then it obviously is best if everyone contributing to the debate, whatever their point of view, can relate their points to one or other of these tests of soundness, because that's what's going to help the inspector most of all. And ultimately, however tempting it is, people like me, for example, would think, well, it's very exciting, here I am being given an opportunity to speak. However tempting it is to think one's, enjoying one's moment in the sun, ultimately, all that really matters is one explaining to the inspector why the plan should be upheld because it is sound, or why the plan shouldn't be upheld because it isn't sound. And that's really what this is all about. You should bear in mind, by the way, that although it's not written in any national policy, there have been correspondence over the years from central government to the planning inspectorate, which is the body to which all inspectors belong, the executive agency to which all these inspectors belong. There's been correspondence over the years from central government that encourages local plan inspectors, examining inspectors, to try to get plans through the process in some shape or form. In other words, trying to discourage inspectors from saying, well, this plan is so shot to pieces, it should just stop dead in its tracks. It's really, there's just so much work that needs to be done to it that even putting forward main modifications, it's going to be a struggle. So inspectors come to these examinations with a positive and inverted commas mindset, in the sense that they do see their task, invariably they see their task as trying to find some version of a plan that can get through the process, rather than just sitting back and saying, well, this plan is a load of rubbish and really should stop now. So you just need to bear that in mind, that the inspector's mindset would be, well, if there's a problem with this plan, how can I fix it? Rather than there's a problem with the plan, goodbye. Also in relation to this great debate about housing numbers, which so often dominates, well, to be honest, always dominates local plan examinations in our modern age, the reality is that inspectors are unlikely just as a matter of practice, are unlikely to find that a plan is providing for too much housing, are more likely to find that a plan is undershooting, is not providing for enough, or to find that the plan is, just about right. It's a stretch, I'm afraid, depending on what one's point of view is, but it's a stretch to imagine an inspector saying, well, I think this plan is really, providing for far too much housing, because of the tone of various passages in current national policy, which prevails against that sort of view being formed. So just running through each of these 4 tests in turn now. So positively prepared is the first test. So providing a strategy which as a minimum seeks to meet the area's objectively assessed needs. And the footnote, by the way, just refers to where the methodology for working out what one's needs are is set out for housing, is informed by agreements with other authorities. So remember, I mentioned the duty to cooperate. That's where one gets these agreements with other authorities. So that unmet need from the neighbouring areas is accommodated where it's practical to do so, and it's consistent with achieving sustainable development. So that strategy there to meet as a minimum one's objectively assessed needs has to be read alongside paragraph 11. We don't need to get paragraph 11 back on the screen, but you'll remember in the plan making part of paragraph 11, we had those 2 caveats. You're to meet needs unless some protective policy designation provides a strong reason for not meeting all of your needs, or unless the harm that would be involved from meeting one's needs would significantly and demonstrably outweigh the benefits of meeting those needs. So although it says here, as a minimum, meet the area's objectively assessed needs, one mustn't forget those 2 caveats there, which are set out in paragraph 11 of the framework. 2, justified, that's to say, an appropriate strategy, taking into account reasonable alternatives based on proportionate evidence. Those first few words, an appropriate strategy, are very important to bear in mind. Poor Marge would have heard me mention the inappropriate strategy at least 10 times every day at the examination into the Greater Manchester Places for Everyone plan. It's not the appropriate strategy, the most appropriate strategy, the perfect strategy, the best strategy, or anything like it. It is an appropriate strategy. So it needs to be borne in mind here that, one might have a very sensible, perhaps very sensible, even a better alternative strategy to the one the local authority's got in its plan. But as long as the local authority's strategy can sensibly, rightly be described as an appropriate strategy, then it's met this part of this test of being justified. At the Greater Manchester plan, every time I mentioned this, I was given a Malteser by my team. So if I mentioned it 10 times a day, I'd end up going back to my workroom at the end of the day and finding 10 Maltesers on my desk. But anyway, it has to be an appropriate strategy, taking into account reasonable alternatives. What on earth does that mean? Well, reasonable alternatives are alternatives which are reasonable in the sense they would meet the strategy that the plan sets out. So, for example, if the plan is seeking to meet certain housing needs and certain employment needs and so on and so forth, and then to be a reasonable alternative strategy, one has to have a strategy which will meet those needs, but in some different way. But it needs an alternative strategy to be reasonable, would need to respect, if you like, the key objectives of the plan that's being examined. And based on proportionate evidence, well, anyone who's ever attended one of these examinations and sees either physically, quite unusual these days to physically see all the evidence that the inspectors have available to them, or looks online at the examination libraries, I think no sensible and sane person would describe the evidence one has of these things as being proportionate. It seems to always be disproportionately heavy. There's masses and masses and masses of evidence. But this part of this test is meant to say to local authorities and examining inspectors, you don't have to go to the nth degree. You don't have to, have evidence in vast detail about every conceivable point that might arise. But the reality is that most authorities are pretty cautious in terms of drawing up their evidence base, as it's called, and will commission evidence documents about, every conceivably relevant subject. That's something which the system is trying to address, but so far hasn't done very well in addressing that sort of vast amounts of material, which, to be honest, is incredibly off-putting even for someone like me who, spends his life doing this sort of stuff. So heavens only knows what it would be like for the people who are listening to my little chat. This vast amount of material, which if you're a concerned local resident or a concerned local amenity group or whatever it is, you've got to grapple with all these documents. It's not easy. I'm sure of that. And then effective, I won't read it all out aloud, deliverable over the plan period, etc. But effective basically is looking to see whether or not what the plan is making provision for is likely to happen over the plan periods. This is to try to sort out the pie in the sky stuff from the more realistic things. So whatever amount of housing you're allocating for, whatever amount of employment you're allocating, whatever amount of development needs for this, that, and something else you're making provision for, is that likely to actually come forward? How likely is that to actually happen during the plan period? So have you got a set of sites which are likely to deliver the goods, or are they, bit of a pipe dream, really? That's what item C is about. And D, well, it's that probably the easiest one to understand. Consistent with national policy means that, really. So you've got policies on all sorts of things in national planning policy, and you're to look at the plan as an examining inspector and see whether or not you marry up with national policy. Local authorities can have their own take on national policy if you like, but fundamentally they have to be consistent with it on whatever the subject is that's being discussed. So there's the 4 tests. I've got an eye on the time. I'm going to have to shut up in a moment. There are 3 things I haven't yet discussed in the list of points that that Marge has set out in the agenda, so to speak. And they're the 7th, 8th, and 9th, the bullet points. So just taking those quickly in turn. What on earth is sustainable development? Well, remember I showed you the presumption in favour of sustainable development earlier on. There's also an overarching explanation of what sustainable development means. I won't ask Marge to share the screen because we need to keep this bit that we've got at the moment on the screen. We need to keep it on the screen. But in paragraph 8 of the framework, you'll find that the framework explains that sustainable development means, here we are, okay, thanks Marge, means meeting economic objectives, social objectives, and environmental objectives. But this is not to be confused with the presumption in favour of sustainable development that I mentioned earlier on, which tells plan makers what they're to do, and not a subject for today's debate. It also tells decision makers what they're meant to do as well. The next bullet that I have yet to deal with is what's the role of the local plan in making decisions on individual planning applications. Well, under the law, section 38, subsection 6 of the Planning and Compulsory Purchase Act 2004, scary, I could recite this stuff in my sleep, but under that section, planning decisions are to be made in accordance with the local plan, unless, there's always an unless in the law, unless material considerations indicate otherwise. So when a planning authority comes to determine a planning application, if that planning application is consistent with the local plan that's been through this vast process that we've been discussing, then if it's consistent with the plan, then that planning application should be granted. If it isn't consistent with the plan, it should be refused. But the legal provision has that caveat, unless material considerations indicate otherwise. So if you meet the plan, but the council wants to turn you down, if they think there's a good reason for doing that, despite you meeting the plan, they can do so. If you don't meet the plan, but the council thinks there's a good reason for giving you your permission regardless, then they can do that as well, subject to an appeal process to the planning inspectorate. And then finally, what's the role and status of all the different bits of the local plan? Well, all important in the local plan are the planning policies themselves, the allocations, the designations, and the policies about particular subjects. Each policy, each allocation, each designation, underneath it, usually underneath it, sometimes it can be both before and after, but in supporting justification and reason justification, the language differs from plan to plan. You will find some explanatory background, explaining, what the policies are meant to be seeking to achieve, giving some more detail, etc., fleshing out some of the background. But that supporting text cannot set out policy requirements, can't say to a person who wants to make a planning application or a person who wants to object to a planning application, well, these are things that you must or mustn't do. So all important in the plans are the designations, the allocations, and the policies on particular subjects. So when one examines these plans or is involved in examination in public, those are the key bits of the plan that one should focus on, rather than a lot of the other stuff in plans. These plans run to hundreds of pages, and probably in any plan about a third or a quarter of the plan is what really counts. So I'm going to stop there because I've spoken for far longer than I anticipated speaking. I'm very happy to run on, by the way. I don't need to be guillotined, if you like, as far as I'm concerned, at any particular time. So, do take your time in asking me whatever questions you'd like to ask. But if I just pause there, not least so I can get a little drink of water. And I'm not sure, but someone is going to, Caroline, or someone is going to be the moderator, or whatever is the right word, and sort of say, well, here's a tricky brain teaser for you. So I shall drink a drop of water, and then perhaps you can give me the first question.
The first thing is, if anybody put a question into the Q&A, I'm afraid neither Rosie nor I could actually see the Q&A. So if you put one there and haven't copied it across to the chat, if you do so now, we'll try and pick it up.
It's all right, Caroline, there's none in there.
Okay, we managed to get the message across then. The first question is from Simon. It says, the examining inspector has an absolute decision-making role. So what quality, performance and accountability measures do they have to comply with?
Gosh, that is an interesting question. So there are various controls, so to speak, on inspectors examining these plans. I mean, first of all, there are legal controls, and so there are legal tests which I've referred to, and the inspector is to write a report. Ultimately will write a report to the authority, explaining his or her view about whether the legal tests and whether the tests of soundness have been met. If there is anything in the inspector's explanation of his or her conclusions which shows that the inspector hasn't really correctly understood the legal requirements or hasn't correctly understood the tests of soundness, then there is the ability to, for somebody who is disgruntled by that, to go to court to bring technically it's not a judicial review, but if one thinks about it as a judicial review, that's the closest fit, if you like. It's actually called a statutory review, but so it's like a judicial review. Someone can go to court, seek the court's permission to bring a legal challenge, and if that permission is granted, then there would be a legal challenge. There'd be a hearing in front of a High Court judge to see whether or not the inspector, if you like, has fallen down on the job. So that's sort of external. That's the law sitting above the inspector. To use an expression that a very famous judge called Lord Denning was very keen on, be you ever so high, the law is above you. And then there are internal quality control standards as well. So the planning inspector has a complaints procedure, has quality control standards. And so the planning inspector can review the performance of its inspectors to see whether they're doing the job as they should or not. I mean, in my experience, and I've done, heavens knows how many of these examinations I've done, an awful lot, many examinations over the years. It's rare to find an inspector who isn't it's extremely rare actually to find an inspector who isn't really aware of quite exactly what they're meant to be doing. And the vast majority of inspectors, and I would say in modern times, all inspectors, if you like, are very well versed in ensuring that the process is an inclusive process, that people are given the opportunity to say what they want to say, subject to the bounds of being, showing respect and not being rude, if you like, to the other participants. So those are fundamentally the controls. There are legal controls, which the High Court polices, if you like, and there are internal controls that the planning inspectorate polices.
Thank you, that's great. There's sort of 3 questions which all tie together, or 2 questions and a comment.
Okay.
First question, I'm afraid I don't, LR. Is there any evidence showing the inspector has reduced the number of housing required to make the plan sound? And then follow on, or coincidental, says being positively prepared means meeting as a minimum the area's objectively assessed needs, which is discussed in para 61, which mandates the standard method unless exceptional circumstances justify an alternative. What sort of exceptional circumstances are likely to succeed in allowing a reduced housing need figure? Yeah. And then a comment is hopefully something like having 57% of the local planning authority's island land inside a national park would be a qualifying exceptional circumstance, especially as it has already been inflated by an affordability index upweight. To date, DLUC an expert opinion is that it doesn't. That's sort of three, but they seem to tie together.
They do all tie together, don't they? And this is why I don't know what one thinks about these things, but local plans are meant to do so much work, or one of my expressions, so much heavy lifting, if you like, and yet pretty much every local plan examination, I think every local plan examination is dominated by a discussion about housing, and the debates are very polarised. The plan hasn't provided enough housing, the plan's provided too much housing, the plan's provided an amount of housing which will cause all sorts of difficulties in relation to whatever it is, the green belt infrastructure and so on and so forth. So in a way, whatever one's view is about the housing crisis, its presence or absence, its degree or otherwise, certainly at local planning examinations, lots of the discussion is around these issues, which are very, very polarising, to be honest, as I've said. So just to deal with the points, but as I mentioned earlier on, I probably sort of got ahead of the first of those questions by saying that, in reality, if housing numbers to be adjusted through this process, the likelihood is that they're going to go up, stay the same or go up. It's, I was going to say extremely rare. I'm just desperately trying to think of an example where the numbers have come down. It's going to be very, very, very rare indeed for an inspector to say, well, you've actually provided for too much housing in terms of the numbers themselves. Which brings me on to the next question, which was that there's a way of assessing housing numbers. You ought to use something called the standard methodology, unless you've got exceptional reasons for putting forward some other methodology which will show what your needs are for housing. What sort of things are exceptional circumstances? Well, this is where, underpinning the National Planning Policy Framework, we have something called the PPG, which is Planning Practice Guidance. This is an online resource published by the government, which explains a lot of these policies in the framework in more detail, fleshes them out. And from the PPG, the current state of play, that's to say, the government has said it's going to change all sorts of things in this, but so far nothing has changed. So the current state of play, looking at the current National Planning Policy Framework and the current PPG, is that one's exceptional circumstances need to be local. And what does that mean? Well, it means, in my understanding of it, it means that if you want to say there are exceptional circumstances, you've got to demonstrate persuasively, you've got to show that the standard methodology has come up with some form of quirk, which is either unique to the local authority in question in terms of not accurately assessing the likely need for housing, or is shared by very, very few other authorities. So, for example, if your complaint about the system is that the standard methodology is shot to pieces, it doesn't actually come up statistically with a sensible way of telling you what your housing needs are, then you won't get anywhere at a local plan examination, because that's a criticism of the methodology across the board, and it just won't wash with the examining inspector, because it's against national policy to say such things, if you like. Sorry if this sounds very sort of, with my East European background, I'm sorry if this sounds very, very much like a sort of Stalinist state of affairs, but that's the way things work. But if you've got something, something about your local authority area, whatever it might be, which shows that the nationally set standard methodology just really isn't to answer because of some quirky situation you've got, then you might have the beginning of an argument. But habitually an inspector is going to seek the sort of safe sanctuary of following the national methodology. It's very, very hard. I mean, to use a sort of non-planning term, you're pushing water uphill if you want to argue that the standard methodology shouldn't be applied in a particular area. As things stand at the moment, I emphasise that because the government has said it wants to change certain things, but as I've emphasised, nothing's changed yet. Yeah, so I think I've probably covered the points you've raised, or that have been raised.
Thank you, Chris. But there's a couple of questions which also seem to tie together here as well. First one, how do you define appropriate and reasonable? As so much of the NPPF is rather vague and open to different interpretations. And then sort of following on from that, can a plan be considered justified if the LPA has not even looked at any reasonable alternatives? Okay,
righty ho. Gosh, then these are jolly. I mean, these are the sort of things that people really do need to sort of get to grips with, certainly when engaging with plans. So yes, words like appropriate and reasonable. I mean, I've mentioned a few times a lot of these decisions that inspectors have to make in making their recommendations to authorities are very judgment call heavy. They involve making judgments, planning judgments, as the jargon goes. And there isn't, you can't really open a book and say, well, in this book you will find an explanation of, in order to be appropriate, X is appropriate and Y isn't appropriate. These are judgment calls, so an appropriate strategy. So let's just think about that. So local authority says, well, yes, we want to meet our housing needs, and we want to meet them by only using brownfield land, or we want to meet our housing needs, but we're going to mix brownfield and greenfield land. We want to meet our needs for housing. We're going to take some greenbelt land to do that, or we're not going to take the greenbelt at all. We're going to concentrate everything on land which isn't greenbelt. So, the local authority, in making its plan, would explain why it considers that strategy is appropriate, and it's then for the inspector to judge whether the inspector considers that strategy is indeed I'm emphasising that, an appropriate strategy. But it's a judgment call. It's a judgment call to be made. This is not law. This is judgment. This is, well, does this seem to be an appropriate way of going about things? Reasonable, one of the favourite words in planning policy and in this world. Are these alternatives reasonable or not? How do you go about judging that? Well, again, it's a judgment call heavy word. But basically, if you've got a strategy, a reasonable alternative to that strategy should be some different way of meeting the same or a very, very similar strategy. That's basically what this all involves. And then could a plan be justified if it hadn't considered any reasonable alternatives? Well, there's a sort of implication, if you like, in the way the system works, that there will always be at least one reasonable alternative which needs to be considered. But if as a matter of law, if you literally had a case where you've got your strategy and you really, really, as a plan making authority, consider there isn't any reasonable alternative to that strategy, then you wouldn't be legally obliged to make up alternatives, if you like. But I think it would be a very brave authority that said, our strategy is X and there are no other alternatives to this that we need to look at or consider. The reality is that in every local plan there are always alternatives that are looked at, and the argument of these examinations is, well, have you looked at all the reasonable alternatives? Isn't there some other reasonable alternative we should have looked at? For example, you know, just thinking about my experience recently that Marge and myself had at the Places for Everyone. Well, you know, you've got authorities going to the green belt. Shouldn't they leave the green belt untouched and, you know, concentrate entirely on brownfield land, for example, or brownfield and greenfield land, but not green belt land? You know, so, you know, the reality is there are always alternatives which are assessed, and the argument is, well, shouldn't you have looked at some other alternatives? But strictly speaking, if an authority thought there were no reasonable alternatives, it wouldn't have to make them up, you know, just to satisfy this. Right, what's next?
Easy one, I think. Where does financial viability fit into the 4 tests?
Okay, well, financial viability will come in at least 2 places. Well, to be honest, it probably comes in each of the 4 tests, but I'll just quickly canter through them. So in order to be deliverable, that's C, effective. In order to be deliverable, then you would need to have, if you're making allocations, you'll need to have sites which are likely to come forward during the plan period. And if they were complete no-hopers in viability terms, then, you know, they would not be sites that could be considered to be deliverable over the plan period. Consistent with national policy, item D, national policy has policies about viability. So, you know, come in there as well. One could always also say that the strategy wouldn't be an appropriate strategy if the strategy was based on putting forward all sorts of sites which weren't financially viable or likely to become financially viable at the point in time, you know, when they're meant to deliver. And one could say that the plan isn't positively prepared, because if you've got a whole bunch of sites which aren't viable, then you're not actually meeting your needs. So financial viability can be brought in under all of the headings, but most directly under C and D, effective and consistent with national policy.
Thank you, that's fantastic. And this is quite an interesting one. Can you apply the soundness criteria to specific plots or sites put forward in the plan if they individually are unsustainable, i.e. no pedestrian access, too far from facilities, even if the overall plan might be sound?
Oh, yes, definitely. Yes, you can, because this judgment call about is the plan sound is made at macro and micro level. So is the overall plan sound, if you like? Is there something fundamentally wrong with it? It needs to be sorted out. But it's also made at the level of each individual policy, each individual allocation, each individual designation will also be tested. So if you've got an allocation and the question is positing that, you know, there's something wrong with the site because, I don't know, it's a long way away from public transport or a long way away from facilities that people would want to use, then you would look at item D, consistent with national policy. In national policy, there's a whole bunch of policies in the framework about accessibility by public transport, accessibility to services and facilities and so on. And you would argue, if you're on that side of the debate, you would argue that the allocation isn't sound because it isn't consistent with national policy concerning the location of a housing site or an employment site or a retail site or whatever it might be. So that's how you would do it. Yeah.
Thank you. This one, interesting. The question is there any provision for the inspectorate saying 3 or 4 years down the line that a local plan is no longer fit for purpose, perhaps because it is no longer sound?
Okay, right. The short answer to that question is no, because the plan is examined at a point in time. The point in time can take many months. Sometimes the process takes years, but eventually the inspector will come to a conclusion, you know, with these main modifications, this plan is sound, over to you local authorities to whether to adopt it or not. Once the inspector has submitted his or her final report on the subject and the ball is passed back, the plan is passed back to the local authority to decide, are we going to adopt it? Are we going to withdraw it? That's the end of the inspector's examination process, and that's the end of the inspector's involvement. So then the plan is either adopted or it's not adopted. And if the plan is adopted, then, you know, it might be a jolly good plan. It might be an absolutely hopeless plan. It might, you know, do all the things it said it was going to do. It might do perhaps few of the things it said it was going to do. And plans are meant to be reviewed as a matter of policy. They're meant to be reviewed every 5 years anyway, though, to be honest, that is often broken rather than complied with. But you know, there's meant to be a review 5 years down the line to see, well, is this plan working as it should? If it's not, you know, do we need to bring a new plan in, or do we need to amend bits of the plan, and then the whole process will start all over again?
Thank you. And then actually, Rosie, do you want to ask your own question, or shall I do it for you?
Oh, I was just trying to find my mute quickly. You caught me off guard there. Yes, so yeah, I was interested in your views on the potential removal of justified from the NPPF that's been put forward.
The potential removal
of the justified, yeah.
My views about it, well, as you'll probably know, many people might know, I've actually sort of been involved in advising government over quite a few years about potential changes to the planning system, and to particularly my key interest, actually, well, two areas were particularly fell to me to, you know, to advise the government about. One was plan making, which we're talking about today, and the other was in relation to environmental assessment. So I am going to sort of hesitate to sort of, I'm not really going to sort of answer your question directly, to be honest. But what I will say is that I think there's been a perfectly understandable misunderstanding about the government's intentions vis-a-vis removing the justified test, the idea of removing the justified test from the test of soundness. It's very easy to say, well, how can it possibly be that you can have a plan which isn't justified? So the idea of removing the test of it being justified, on the face of it, can be dressed up as, can be said to be a very strange idea indeed. The reality is that the test of justified, the idea of removing it, has been put forward simply because parts of that test have proven to be extremely onerous, not in the sense of, you know, passing or failing the test, but in the sense of the amount of material that authorities have thought to themselves they need to commission in order to support a plan. So the idea of removing the test of justified is actually addressed very largely at that bit about proportionate evidence in the framework, because the planning system has struggled to convey the message to authorities and to inspectors and to people who don't like plans and object to them, that actually these plans, you know, aren't meant to be the subject of vast amounts of supporting material, vast amounts of evidence, vast amounts of supporting documentation, because that makes the system so incredibly unwieldy. So I think there's, as close as I'm going to get to answering your question directly, forgive me because of my personal involvement in all of this, is to say that there is, I think it's fair to say, there's an understandable reason why the government is proposing to remove this test. But I also understand how easy it is for people to quite genuinely, without being malevolent, you know, quite genuinely misunderstand what the government's seeking to do in removing the test. And I better stop there.
No, okay, that's fine. Sorry if I put you on. Sorry if I put you on the spot there.
Not at all.
I'd certainly agree that the evidence that's provided is not necessarily useful evidence, and you can have piles and piles of just tick box, and it doesn't relate to itself, and so so I'd agree with that. But we will, yeah, leave that one there. Thank you.
Leave that one there. But
yeah.
but in that particular point, I mean, one of the things that I have in the past advised the government about, which has been brought forward through the bill, which is going through Parliament, is this idea of trying to make environmental assessment, which would include the environmental assessment of plans, much more readily understandable and usable and useful, if you like. I don't want to sort of promote my own ideas here, but there's no doubt at all that the existing system, which produces a vast amount of material, which, if it's ever read, and I do question whether anyone ever reads all of this stuff, if it's ever read, you know, is it actually helping one to do one's job? You know, whether that's the job of promoting a plan, objecting to a plan, or deciding whether the plan is sound. And I do question, to be honest, whether much of the material that we have, you know, landed upon ourselves, or that we land upon ourselves, whether much of that material actually sort of is necessary. But it's just a personal sort of gripe of mine. I better have another swig of water before I get too carried away.
I'm conscious, Caroline, that we have got more questions, but we are already coming way past our time. Chris, would it be possible if I dropped you a note with these extra questions in? Would you mind having a look at them outside of the meeting, or?
Well, if you're happy to run on a bit, I'd rather sort of deal with them.
While we're
in full flow, because the reality is
to do that.
Once I bid a fond farewell to all of you lovely, lovely people, and you say, well, we've had enough of this chap talking to us, once I bid a fond farewell to you, I'm afraid the rest of my life will come back into play, which will
but
be
you're
people
very
asking
busy.
me to.
We know, we recognise that.
No, that's right. It's just I'm very, very fortunate that people are crazy enough to want to take my advice about things. But
okay, let's carry on then, Caroline. We'll do a couple more.
Yeah, I think we've got 4 more.
Okay. That's fine. Let's
a local planning authority has given outline permission for around 10,000 dwellings, but feels it cannot demonstrate a 5-year housing land supply of 1,100 a year.
Right.
But that's because of low build rates. Can this be challenged?
Can this be challenged? I wonder what the questioner means by can this be challenged. I see. Well, the local authority's view about the 5-year supply. Okay, let me just see. So yes, this is one of the great sort of problem areas of planning. What everyone's perspective is, we're not building enough houses. We're building far too many houses. What everyone's view is, this whole debate around the 5-year housing land supply is again another polarising area of planning. To answer the question directly, if a local authority decides to grant planning permission because the local planning authority, thinks for whatever reason, whether it's because of build rates or anything else, whatever the reason is, because it thinks it hasn't got a 5-year housing land supply, therefore it thinks, well, we need to grant a planning permission for housing. Here we are, we're granting this permission. Then the only remedy in those circumstances is the Secretary of State, central government, has the power to call in that decision, to take it away from the local authority and to appoint an inspector to have a public inquiry and consider whether or not permission should be granted, and report to the Secretary of State, who would decide whether the permission should or shouldn't be granted. So that's an ability for central government to take the case away from local government. That power, forgive me, is very rarely exercised, and it happens every now and again, but only in major controversial cases, and the vast majority of cases where a local authority decides to grant a planning permission for housing because it doesn't think it's got a 5-year supply, are not going to be called in by central government. So in those circumstances, local authority grants a planning permission. And the only recourse then is a potential judicial review, a legal challenge to that decision, but a court would only interfere if the court considered that the local planning authority had not correctly understood the test involved in showing there's a 5-year supply. A judicial review would never impinge upon the council's planning judgments about matters of debate where reasonable people can hold different views about the answer, and if the local authority's gone one way, a court is never ever going to say, well, you should have gone the other way on that. So judicial reviews are there, but the reality is the vast majority of planning decisions made by local councils stop there at that local authority level. But yes, I mean, if they've dropped a clanger and just haven't understood how it all works, or they've made some error in assessing the presence or absence of 5-year supply, then at least in theory there's the ability to judicially review that. Although I'm a lawyer, and although I go to court, and although I do judicial reviews, I wouldn't want to mislead anybody and think that judicial review is some sort of panacea, because it only ever works in relatively few cases.
Thank you, Chris. Right, it says inspectors showed little interest in examining whether a plan is contributing to the mitigation of climate change by ensuring that development goes in the most sustainable locations. Do they get adequate training?
Well, They get a lot of training, I can tell you that much. I've actually participated in some of this training, so I've actually seen with my own eyes, you know, how the inspector's main sort of training works, and you know, it is rigorous and there's a lot of it. And I've often thought, who would want to be a planning inspector? Because it's very rare that one ever gets a pat on the back, if you like, as a planning inspector. But there you are. In a way, the issue arises from the way in which the question is put, because the question was along these lines. The inspector hasn't shown much interest or any interest in examining whether a plan is sound in the sense that it's allocated a site which is not in the most sustainable location. Well, in a way, there's the problem, because the test, as I said, of soundness in relation to justified is that one has to have an appropriate strategy, and you can have an appropriate strategy which allocates sites which aren't individually in the most sustainable location, but which are sensible sites to allocate for other reasons. So if I just turn this debate on its head, just to make it as stark as possible, you know, and not want to say, you know, my view is X or my view is Y, but if you just think about it, there's some very, very sustainably green. There are some very, very sustainable greenbelt areas. You know, if you have greenbelt right next to a railway station, you could say, well, there's an incredibly sustainable piece of land. Let's allocate it. But another point of view would be, well, no, we're not going to allocate it because it's greenbelt and it needs to be protected to preserve the openness, you know, that the greenbelt's all about. And so then that means you'd go to some less sustainable location to meet your development needs than the greenbelt site, which is right next to the railway station. You're going to a less sustainable location. So how do you grapple with that? Well, the judgment call is we're having to go to less sustainable locations because there are greater public interests, which mean that we can allocate this site which is more sustainable in its location. So you can see, just as I'm taking it, it's not that extreme an example actually, but I'm taking an example to, you know, quite a stark example just to make the point. So just remember all the time that the key phraseology is, at the moment, is an appropriate strategy, not the most appropriate or the most sustainable or whatever it might be. So the inspector's disinclination to examine, you know, as the question said, I mean, I don't know the particular circumstance of the case, obviously, but might actually be because of what I've just said. The inspector's task isn't actually to find the most sustainable, the most appropriate, the best, but to actually see whether what's being put forward is reasonable enough, if you like, is an appropriate strategy.
Thank you. Another one, if the issues and options consultation contained incorrect or leading details, for example, the wrong land supply position, could the process be argued as being unsound?
Okay, issues and options. So right at the beginning of in terms of the legal structure of all this, local authorities go through what's called a Regulation 18 stage, which is where they set out their well, they basically say to the public, you know, we're about to make a local plan to embark on this process. You know, here are our views. Most local authorities would do it this way. Here are our initial views about what we should address in this plan. What do you think, you know, we should do? And here are some options. You know, should we, basically, you know, should we, you know, review the greenbelt, take greenbelt land out to meet housing needs if you're in a greenbelt area, or should we not touch the greenbelt? You know, there'd be the two most obvious options in an authority that's got greenbelt, or if you're nowhere near a greenbelt, you know, should we focus entirely on brownfield sites? Should we go into the countryside and take greenfield sites? Set out those options. Everyone has this. Anyone who wants to have their say about it has their say. And in the next stage later on is the Regulation 19 plan, which is the plan that the council wants to submit to the Secretary of State for examination. So basically, if there's something at that first stage that you as an individual take great exception to, you think it's misleading, you think the authority has got something wrong, then the way the process works is that you're meant to, you know, write into the authority and say, well, you've got this wrong. Your assessment of development needs is excessive, or, you know, I'd be surprised if the point was that you haven't provided enough development, but that you've got this judgment call wrong. Here are my views about it. The local authority then may consider that point and agree with it or disagree with it, and the matter moves on. So the reality is that I can't really conceive in practical terms of a plan being examined, at examination stage, being found to be unsound because of something that happened at that first main stage, issues and options. It's highly unlikely to, in my experience, to consider a plan being, or contemplate a plan being, tripped up at examination stage because of something that one takes exception to at that issues and options stage. I'm not saying it's impossible, but it would be a rare case.
Thank you, Chris. And then the last one, you'll be glad to hear.
No, I'm enjoying myself.
This one I can imagine. The duty to cooperate is a major source of contention between neighbouring local authorities, with each one maintaining that the others should take some of their allocation.
Yes, absolutely.
Does it make a difference if one has not had an adopted plan for a long time, 1998, and another has a more recent plan, 2016?
Well, no, that's an interesting question. They've all been interesting questions, actually, if I might say. The real brain teasers you've been setting me. As you can tell, this is the KC waffling away to give himself thinking time. So in terms of the duty to cooperate, yes, it is a major bone of contention. And as I say, one of the reasons why it is such a bone of contention is because it is the only pass-fail test in the whole plan-making system. So authorities making a plan really have to go to, make sure they have to be very careful to make sure they've done everything to demonstrate that they have actually met the duty to cooperate. It is a real bone of contention because the reality is that certainly in areas which are under major development pressure, and depending on where you live, participants in this call, you may very well be in one of those areas of the country where there are huge development pressures that seem, so difficult to cope with. And yes, you do find this process of authority A saying, God, we've got this huge number of homes. It's usually homes, isn't it? Let's not beat about the bush. Huge amount of homes that we need to provide for. We don't think we can do it. We want you to, we're asking you to take, a quarter, a fifth, whatever it might be, of our housing needs and deal with them in your less constrained area, because you've got less lovely countryside. You've got, you haven't got a national park. You haven't got area of outstanding natural beauty or whatever it might be. So therefore you can take more of our you can take some of our burden from us and meet it next door. Now the duty to cooperate is one of the odd things about it, you might think, is that it is a duty to discuss. It's not a duty to agree. So ultimately the plan making authority, as long as it's considered all the points that have been made by its neighbours, can say, well, thank you very much indeed, but we've decided that we can't accommodate any of your extra overhousing needs, so to speak, because we've also got our own constraints here. So we're meeting our needs, but we can't without impinging too much on sustainability policies. We can't take any more than our, for example, our nationally set number of homes. It is a very, very contentious area, and one of the government's proposals is to get rid of it because, to be honest, it's been the source of a lot of confusion in the system. And if one stands back and thinks about it, one might think to oneself, well, is there that much point in a duty to discuss, but not a duty to actually ever agree anything? Isn't there a better way of going about things? But that's a debate for another day.
Well, thank you very much. That's all the questions. Marge and Rosie, I'll pass back to you.
No, thank you so much, and some really great questions, lots of interesting points, and we could talk for a long time about these issues, couldn't we? And I'm sure we'll be coming back to it again and again. So but I'd just like to say a huge thank you, Chris, for coming along. Really do appreciate it. And it's been a very interesting discussion. I hope we'll be able to get you back again then when the new NPPF is
Yes.
issued. And,
oh yes.
yeah.
Yes, indeed. Where you might have a sweepstake to see when you think that might be. Because as with all these changes to national policy, they're always, they're either going to be spring, then spring comes, it's summer, and then summer comes, and people think, oh gosh, what's going to happen now? So it then becomes this year. And I think at the moment, changes to the NPPF are said to be due in due course. In due course, I think is the latest position.
Exactly.
That's the move.
Thank you very much.
From spring, isn't it? Yes, thank you. Anyway, and thank you for everybody that's joined us as well.
Yes,
I think it's been said in the chat. We're going to put the recording of the session on our website. So that will be available tomorrow. I'm sorry, my dog's just jumped on my knee and I can't get
marvellous. Excellent.
So
I'm in my office at the moment, but if I was at home, I'd have dogs and cats jumping around all over the place.
Oh dear, sorry about that. That was a distraction. Okay, so we'll see you again soon, Chris, and maybe see you on the 5th of July. We have some more hearings coming up.
Go back to Manchester for some more discussions, of one of your favourite subjects as well, Marge.
Yeah, my favourite subject. Well, I have to say, to be fair, the planning inspectors have looked very carefully at a lot of issues, and we are coming back to talk about Pete and statements of common ground about Pete.
By the way. Pete is the stuff we used to put in our gardens, but we never can't do so.
Excellent.
So anyway, right. So I'll see you on the 5th.
Thank you.
Yeah, and thank you so much again, Chris.
Thank you all
bye for now, everybody.
very much indeed. Thank you. God bless. Bye now.
Bye-bye. Thank you.
Bye.